Hey guys, welcome back. First live stream for 2021. And it has to be a better year than 2020. So, welcome back and let's get started. So tonight, let me do the formalities. Welcome to Advocates for Justice Foreclosure Defense Paralegal Service. We are different and we prove it. I'm Coach Neighbors and I'm the one that gets to blow the whistle around here. So today we're going to talk about how to control attorneys in a hearing, and we also going to talk about a few new things that we got up and running. I'll give you a link to those things. Hey, James Galley. So, how to control attorneys in a hearing? Let's just get started. Oh wait, before we get started, you guys click the bell down there and click the bell and subscribe and ring the message and all that other stuff that you're supposed to be doing. You guys remember from the other videos, right? Okay. Subscribe and click the bell so you get notifications when class starts. So today we're going to talk about how to control attorneys in a hearing. And the first thing that we're going to talk about in that is when there's a hearing, the first thing you have to do is introduce yourself before the attorney speaks. Introduce yourself as a state citizen of the republic state that you were born in, and move to dismiss the action with the oral motion to dismiss, because the attorneys do not have a witness. Without a witness that signed the petition, the court has no jurisdiction to move forward. The attorney is the only party to sign the petition, and therefore the plaintiff in this action is not the lender as listed on the front page of the petition. And that's a fatal flaw, because the attorney is lying to the court. The attorney cannot testify. And anytime the attorney speaks, you should jump up and object. And when they get done asking you why you're objecting, you need to tell them, because the attorney cannot testify. And you know the game they play to try to help each other out, kick your butt in court. So you need to tell the judge, if the judge is going to allow the attorney to testify, you need to object first, so you have it on the record. And then you need to let the judge know that if the judge is going to allow the attorney to testify without a witness, without an injured party, and without a witness, the judge must swear the attorney in under oath so you can cross-examine the attorney, because you have the right to cross-examine anybody in court that's offering testimony. Anything out of the attorney's mouth is freaking testimony. End of the story. Okay. And the problem with that is it's third-party hearsay, because the attorney was nowhere around when the situation that caused the dispute took place. So the attorney cannot testify. And if the attorney is going to testify, then you want to have the judge swear the attorney in, and so you can cross-examine the attorney under oath. And see, that's a big thing, under oath. When you force the attorney to speak under oath, it's a problem, because they're lying and everything they're doing is a lie. So they can't do under oath. They can't do by counter affidavit either. Our jurisdictional challenge with an affidavit is blowing them out of the water, because they cannot respond by counter affidavit because they're lying. Now I've added the attorneys as a number one defendant to the wrongful foreclosure lawsuit to be filed in federal court. And that's what I would tell. I would tell the judge that you've added the attorneys to your wrongful foreclosure lawsuit that you're going to be filing, or that you already filed in federal court. And now the attorney is a litigant in the case. The attorney cannot represent himself, and the attorney cannot litigate a case that they're a party to. And here's the third thing that you need to keep in mind, because this is going to be a pivoting point for you. The attorney cannot represent the law firm that they're affiliated with. The rules will not allow that, because a corporation cannot go into court pro se. So remember those three things, because you're going back to attorney in a corner for real up in here. And when the judge helps the attorney and ignores all of these things, then you're going to turn your sights on the judge and sue the judge for taking jurisdiction without legal authority. So at the end of the day, it don't matter who you sue. It don't matter if you're suing the attorney, the clerk, the judge, the third-party debt collector. It don't matter, or if you end up with all of them. But before you put all of them on there, you need to remember that the more people you have on there, the more complicated it becomes. And it's more complicated for you because you have to respond to all of their replies, and you have to reply to all their responses and do all of that stuff. So what I like to do is have in the top right-hand corner that you reserve the right to amend, and just leave the least amount of people on there as you can, and then change if you need to later. But in most cases, you won't need to, because the signature that's on that petition, the signature on the paperwork that started the foreclosure against your house, is the main person that you should have on your is the main person that you should have listed on your lawsuit. Hey guys, I got 5 people watching. You guys let me know who's here so I can take roll. So we're going to move forward. So there's a fatal flaw in the attorney's action, because the attorney lied to the court, and the attorney is the actual plaintiff acting as a third-party debt collector, trying to hide behind the lender. And this is the biggest mistake that most people make in foreclosure defense. The lender is not the one that's foreclosing on you. Okay, it's not the lender. Okay, and people need to understand that the illegal mortgage fraud and the unlawful foreclosure are 2 entirely separate situations orchestrated by 2 entirely separate parties. And if you have the wrong party for the wrong thing, then they're just going to let you flop around in court till you run out of money. Then they're going to kick you out of court under Rule 12B for failure to state a claim, because you did not add the party to the lawsuit that's actually suing you. And that's the third-party debt collector attorney. And if you check the paperwork that's used to initiate the foreclosure against your property, you will see there's only one signature, and it's not from the lender. The lender don't sign anything anywhere. The lender does a charge off, and they claim that on the alleged loss on their taxes. They claim the alleged loss on the insurance. And anybody that understands the GAAP accounting principles would know that when you're done doing that, there's no place left for you no entries to add additional income that you're making off of that. That's done. It's closed, and it's a done deal. Now, you can go on the internet, and it says all the time, oh yeah, the third-party debt collectors, they can collect even if it, no, bullshit. That's not the way. I mean, they do, because they're the ones that made the rules, and people believe what they say, but they're full of crap, and they're violating you. So, and that's what we address. So you must object every time the attorney opens his or her mouth, because the attorney is not allowed to testify in court. And I would tell the judge, like I said, if he's going to allow, he or she is going to allow the attorney to testify, you want the attorney sworn in so that the attorney's testimony is under oath. Otherwise, the attorneys lie. We already know they lie when their mouth's moving. So another thing that I would do is an oral motion to strike the attorney's notice of appearance, due to the fact the attorney is a foreign agent, and as such must file their claim in federal court. No foreign entity can file a claim against a state citizen in state court. It has to be filed in federal court. That's not the way it works. This is like the easiest thing to move to get your case dismissed. And if you can get this verbally on the record, you're going to go a long way to getting control of this situation. The attorney is a foreign agent, and that is why they have to file a notice of appearance. They're a foreign agent, they have to file a notice of appearance. So you should do an oral motion to strike the notice of appearance, or a real motion. I actually have one in the packet that I sell to strike the attorney's notice of appearance. I'm going to add the fact that they're not registered under the Foreign Registration Act to that. And that's what we're going to talk about next. And this is powerful. The attorney is in violation of federal law. The Foreign Agent Registration Act of 1948, I think it's 1948, mandates that all attorneys have to register with the National Attorney General. Yep. Go to their website, go to the DOJ website, and it says, I had no idea there was a National Attorney General. That's who's supposed to be taking care of all of this stuff. When the attorneys don't register and they're going to court, they're in violation of federal law. And the Foreign Agent Registration Act was actually enacted into law, in federal law, in 1948. And if the attorneys do not have the proper registration paperwork, then they have no standing in court to be up in your face. And they have no standing to be in state court because they're a foreign agent. And that is why they have to file the notice of appearance before they go into every case, because they are a foreign agent. And see, attorneys ain't gonna tell you this kind of stuff. And most people ain't, because of the fear. But I'm not worried about the fear, because they already done what they want to do to me, and now it's my turn. So I'm helping you guys learn how to stay in your house and how to get them out of your face. Because I became obsessed with learning the loopholes and shit that they're doing that they used to kick my ass with, and now I'm helping you guys learn what they are, so you won't get your ass kicked with them. And I love what I do. And you guys see my Chiefs shirt. Go Chiefs! Okay, I had to squeeze that in. Now, I would tell the judge that you're a state citizen from a republic state that you were born, and you're not subject to this administrative court's jurisdiction without an injured party. And if the judge decides, in a case where he has or she has no legal authority, the judge will be obstructing the administration of justice and placing himself in a position for civil liability. Now, obstructing the administration of justice is how you put it when you're in civil court getting screwed. Now, in criminal court, it's violating your due process rights. But in civil court, the judge is obstructing the administration of justice. And a lot of people don't know that. If you use that term in court, you will get their attention. And you could tell them that your legal team said that they're obstructing the administration of justice. And your legal team is the one that's running the show. So you always want to refer to your legal team. Now, we are finding these crooks are not used to being held accountable. So they will just keep working together and try hard to get their agenda done in court. So you need to be focused and work and let them know that you mean business. And that's what you're going to be doing in my program. You'll be letting them know you mean business by how you roll and what you bring to the table and what you say in the hearing. If the judge violates you, you must take action ASAP. And you do this by filing your objection and your motion for reconsideration. You add a file stamp copy of everything that you filed in the case that the judge is ignoring, and you attach it to your motion for reconsideration, your objection and motion to reconsideration. And then the next day or so, you're going to file your motion to recuse the judge. And then you also have a notice of claim against the judge for taking jurisdiction without legal authority. Now you will see how long it takes him to come up with another judge for your case. Now we have this going on right now in a case that I'm helping a family member with. And it's been, I don't know, 4 or 5 weeks that we're waiting for the new judge to be named, because the old judge came in, the first judge came in and tried to ignore all of the filings that we filed. And they tried to do what they call a summary, a journal entry. Yep. And we wasn't having that. So a journal entry is just when the attorneys agree to throw you under the bus and then the judge just signs on to their agreement. So the judge can get out of ruling in the case. Yeah, we was not having that. So you can avoid all of that by attacking the judge as soon as the judge violates you in court. That's what you have to do, because we've been learning with our Facebook group, with the members in our Facebook group, they've been providing me real-time feedback about how these attorneys are trying to get out of being held accountable to what we're trying to do. And it's allowed us to cut to the chase. So right now, the judge is helping them because the attorneys are backed into the corner big time and can't really do shit without the judge helping them. So we put together a new package to go after the judge for helping them when the judge helps them. And like I said, we got what's going on 5 weeks now that we have been waiting to hear who the new judge is going to be. I think my family member's case is a hot potato now, because the judge and we found out Monday that there's a 7th new attorney that signed on. So we're getting ready to move to strike his notice of appearance. And I think we'll probably serve our sanction motion for $5.5 million on his ass and see how they like that. So we're finding out this is the first case that I've had that we've held in state court. We're doing pretty good, so I'm refusing to move it to federal court. But we got a plan for that if we need to. So when you do get your case filed in federal court, your title dispute filed in federal court, then you could do a notice of removal. I can't talk today. You can do a notice of removal and move the attorney's lawsuit over to federal court without paying fees, because the other state court judges have a conflict of interest. Think about it. If you got a notice of claim filed against a judge, then no other judges can really rule on the notice of claim or rule on objecting or any of that stuff, because you've already proved that the judge has failed to be impartial. So, and I actually did this with two $10 seatbelt tickets, moved them to federal court and harassed them in federal court for over a year. So these tactics work pretty well. And you got to understand that these attorneys are the ones that structured the program, the legal processes and the program, and they're not structured to help for us to be fair. So they're not structured to be fair. So that's just the way it is. So you can't follow all of their shit and expect to have anything good happen to you. So what we did was we moved the $10 seatbelt ticket to federal court, and we dragged them in federal court for a while. And after a while, the court, see, the way the courts work, they have to get your case done and get you thrown under the bus in a certain amount of time. And if they can't get you done in that amount of time, it's a problem. And then other people start complaining, and then people start yelling at the attorney why they can't get control of you. And yeah. And now they want to get the case dismissed or handled or something done to get it out of their face. So once you file your title dispute in federal court, you can move for summary judgment based on the fact that the attorneys failed to respond to your jurisdictional challenge with an affidavit in state court. Now the attorneys have to prove jurisdiction on the record in federal court, or they'll be wasting the court's time and resources. Nice how that works out. You can use all of that stuff that they didn't respond to and tried to get around and ignore in federal court as evidence, in state court as evidence in your federal court lawsuit. So you want to use the jurisdiction challenge as evidence in your foreclosure lawsuit that you file in federal court. And I would file a motion direct in federal court to order a settlement hearing, because if the attorneys couldn't prove jurisdiction in state court, they're not going to be able to prove it in federal court either. So it's going to be a waste of court time to have a hearing and go through all of that stuff when they don't have nothing and the attorney's lying. So now you can use the federal court to control the lower court, when the state court judge tries to continue and ignore your federal court claim, you can ask the federal court to call down there, or you can file your restraining order in federal court and ask the judge to sign it, blocking the state court process. Now remember, federal court's a higher court than state court, so that court should automatically trump anything that's going on in lower court. But with the fraud, we have to do some other things. So that's how we roll on that. That should give you guys enough firepower to jam the judge up or jam the attorney up in hearing and make the judge decide that it needs to continue. So the next thing we're going to do is I'm going to show you guys some of the new stuff that we got put together. I'm going to do a screen share here as soon as I figure out how to do it. Okay, so we want to screen share that one. Okay, so this is the screen share. We're going to show you guys now. This is our credit card lawsuit package that we put together. I actually put this together for a while. I'm just now kind of getting around to marketing it. People have found it and have been using it. So I upgraded it and I put it on this new website, Samcart. Samcart is a place where you can go and just make a one-page site. And my WordPress website that I usually use is struggling, and there are some updates, and for some reason the updates are not meshing with PayPal. So not all of the documents that people purchase are being downloaded properly to them. So if you purchase something, if you make your investment and you can't find your download, just email me at winincourts1@gmail.com and let me know that you didn't get the download, and then I'll look into it, verify that you did make the purchase, and then I'll email you over the download, because when I check the PayPal thing, it usually leaves me your email address, so I'm able to do that. But you can see here that we put this together. These debt collections are totally illegal, what they're doing, and they're kind of the same thing with the foreclosures. So we put this offer together here, and I'll leave a link to it in the page, so you guys will be able to go to it if you're. Those of you guys who follow me on Facebook, I love my bomber planes, so I was able to use one of them in here. Now you have the firepower to fight back. And then we go through the credit card lawsuit facts. I'll give you a little bit of history here of how bad you're getting the shaft on these alleged credit card debts. And then here you need to invest in this package so that you can stop the credit card lawsuit, stop the wage garnishments, sue the third-party debt collectors for $1.5 million, or you can move that up to $5 million in state court. We have to go a little bit lower, but you can move this in federal court too, which is what I would do. I wouldn't mess around in state court unless you just wanted to screw with them. Yeah, there's that. And you see, it's time to stop playing around. And then I have the instructional video for filling out the lawsuit package here, along with one of my boxing pictures. Yeah, I love boxing too. So you see, I got somebody getting shit knocked out of them here. And then these are all of the things that you will get in this package. Plus, you're going to get some free stuff that we'll discuss down below. Everybody likes free, right? And then these are some of our reviews that I pasted from Google in this fancy program that allows them to go across the screen like that. And this is the free stuff. So in this package, you're going to get the jurisdictional challenge with an affidavit. This document we're using to stop the state court processes. This package is a $850 value. You're going to get completely free. And if you're already in court, if they've already dragged you in court or during a wage garnishment or whatever, then you can use this to stop all of that and put you out on the 50-yard line so you can start throwing some passes to the end zone. That's what this is about. So this package is set up with what you need to stop the state court process if they already drag you in the court. And I just threw it in free because I want to have a package set up to get things done at one low price so I don't have to nickel and dime people to death like attorneys do. So now this package I have on special half price for $2.99, I think. And this I've added these two packages to all of my lawsuit packages pretty much. And this is the package you need to slap the magistrate judge or the district judge. It don't matter which judge. I have magistrate judge on here because magistrate judge is usually the one that throws your shit out of court. Well, excuse me. Magistrate judge is usually the one that writes the report that they give to the district judge to throw your shit out of court without ruling on the merits. And most people don't realize that their stuff is being thrown out of court based off of an administrative hearing, an administrative process. And I say that because if your stuff got kicked out of court, you get your paperwork and look at it. You'll see that the district judge dismissed your shit based off of a report from the magistrate judge, not the district judge's facts of findings and conclusions of law. They drag you into their administrative court where they don't have to give you any right to do anything except screw you over. So this document has what you need to object, move for reconsideration. It has the motion to recuse the judge in it. It also has a notice of claim against the judge, and yeah, so you can get that done. This package here has you're challenging your jurisdictional challenge with an affidavit. The attorney can't respond by counter affidavit because they're lying. And that's plain and simple. And this package, you'll also get a motion to moot all the attorney's pleadings until they prove jurisdiction on the record. You'll have a notice of default to file because they're not going to be able to answer to it on the merits or by counter affidavit. They also have a reply. I've had them once or twice respond with their weak ass reply. So with their weak ass response. So I replied to their weak ass response for you, and that's included. And then you have a document for summary judgment and a motion for a hearing as soon as they find you a new judge. Yeah, we learn how to do it up in here. And you can see this package is affordable. So your credit score, when you attack these in the documents, you are demanding that the attorney contact the credit reporting agency and remove the false information that they reported to them. And the people have used this. I haven't had one time where they had any kind of a trial. Most of the time, they don't even go to that. And the attorneys get on the phone and they call and they make that call to help clean up your credit. And this is the fastest way to clean your credit up and fix your credit score. You force the attorneys to get on the phone and call them people and tell them the truth instead of the lies that they told them in the first place. And your credit score will go up overnight, just like this little guy here pushing the thing over. Now, my guarantee for the online course is you have like a week or something to decide if the course has value. For my documents and my lawsuit packages, I don't do the same thing because I got people trying to scam me. And I have one person already tried to scam me on the property tax lawsuit package. Okay, the property tax lawsuit package, the dude's trying to scam me on. It's sad. And they don't realize that when you contact a bank and say that someone fraudulently purchased something, that they called me and they asked me about it, and they have me send them all the information that I have to prove that you're lying. So when people, before they purchase, most people call and email me. And so I have the emails address, and then a lot of times I send you extra stuff. You know, I've been including the jurisdictional challenge with an affidavit when people purchase the package, just so they can get the shit stopped and have a chance. And I did not charge the dude, and he still tried to scam me. So I sent 5 emails of him. He said that he didn't know anything about the charges and that they're fraud. Well, his emails are going to show that he knew about the charges, and he asked me questions about the package. So there you go. So we had to change that just to make it so that's fair for everybody. At the end of the day, you should go to my YouTube channel. You should go to my Facebook page. You should go to my Google reviews. You should read my disclaimer on my WordPress website, and you should read and you should do your homework. By the time it's time for you to decide if there's value in investing in my program, you should already know how I roll. You should already know how I roll. If you don't, you haven't done your homework. And when you call me and you ask me about stuff that's posted on my thing, I'm going to tell you haven't done your homework, because I'm not going to spend time going over what I have posted, so I don't have to go over that. See how that rolls? So what works best for me is if you do your homework, and if you find value in what I do, make your investment. Review what you get. And if you have a question, you can contact me in the group where we do the group coaching, because we're too busy to do the phone calls. We do the group coaching. You can contact me in the group and you can ask me questions. And now we're talking about your strategy to kick ass instead of what you get or how long it's going to take to fill it out or all of that stuff that I have no answer for you for, because that stuff is going to depend on how much homework you've done and how well you know what the hell you need to be getting done. So now that's the first one. And that one's kind of cool. It's time to stop this. Yeah, this. We need to stop this. Yeah, I got some really nice attorney fraud pictures. And like I said, this offer is on sale for $2.99. And I have several people that are using it already. And I know things are going well when I don't hear anything from anybody. But the people are using it. I would like to have a review if you found value in it, so other people can see that is real. Now, this one, that's the same one. Let me get rid of that one. Okay, here, this one here. This one is the new Eliminating Property Tax Lawsuit package that teaches you how to stop your property taxes in 60 days or less, even without any legal experience. And there's a guarantee. And like I said, I'll leave a link to these so you guys can check them out and take a little more time on them. And I go into my story a little bit about how I arrived here to this property tax situation. Pretty much it was because I had 3 or 4 people facing a tax lien foreclosure, and I needed to figure out a way to help them. So, and we got facts about the taxes and what are your rights? Well, the Constitution and property taxes pretty much says it all. It's illegal for them to charge tax on private property. And it states that not once, but twice in the Constitution. Got good news, because I got the solution that you need. Eliminate property tax lawsuit package. Invest in this package so that you can force the attorneys to follow the real estate deed transfer laws and deliver your deed to you. And you know, the deed issue. I post this. So the people in California were pissed about my eliminated property tax package, and I've had like 2 correspondents, one from an investigator and one from the deputy somebody or whatever for the Bar Association for the state of California, and they're pissed about my eliminated property tax lawsuit package. But it's kind of funny. I haven't figured out if they're pissed because I'm only asking $4.99 for the package, or if they're pissed because the package is exposing their fraud. So I'm not sure why. Maybe it's both. I don't know. And you guys can see, I don't freaking care. So, oh, I love this. Dream big and make it happen. So these are the other benefits that you get: blocking the eviction process, stopping the property tax lien process. This document will block the eviction process. It'll stop the tax sale. And you can use that money that you've been paying for these property taxes for a new car, or you can send the money to me. Okay, sorry. I got carried away now. Now I sound like an attorney. Sorry. I got carried away. And you can block the city from controlling the use of your property. You can block the city from interfering with your with you operating your short-term rental businesses. Or you can also block the city from interfering with your Airbnb. You can operate your Airbnb without the city harassment. Now, I love this picture here. You know, it's time to stop throwing your money down the toilet. And this is the property tax instructional video. Now, in this video, I state that, once you get your pack, get on the phone and we'll gonna do a call. Well, we don't do the calls no more. That was when I first put this out, when it was at $850. Now it's been reduced to $499, and I got so many calls that I don't have time to do phone calls for everybody, and that's why we went to the group coaching. So if you invest in this package, you can find us on Facebook. Foreclosure Rescue is the name of our group, or you probably can find it by Googling my name and let me know that you purchased the property tax package and you'd like to get in the group and see what's going on. And then we have some more reviews. And I need to make another video to put here. I just reminded myself of that. So there's that again. We're going to stop that. I think I got that on everything because I like that. We need to stop that. As you can see, this package is on sale now for $4.99. It went down now $1. Well, every dollar counts, right? Okay. Now, this next one, this is the new one. Hot off the press, and this is fire. So this is the new package for the non-judicial foreclosure defense. Now, this non-judicial foreclosure defense, so I went through the judicial foreclosure defense, and that's pretty much what I based my packages on when I first started doing this. And I had people in non-judicial that was filing a lawsuit, but they were still being violated in the eviction court. So I had to go back to the drawing board and do a little figuring out how the hell they were doing that. And basically what we figured out is that so most people think that when they're doing judicial foreclosure, the most important thing is to have a process to block the sale. And you just got hosed. That is not the most important thing. The most important thing in a non-judicial foreclosure defense strategy is to have a plan to block the eviction process. And I'll tell you why. The sale can take place all day, okay? And then they still have to go to court to evict you and get you off the property and do all of that. If the sale takes place, you can jam the sale up by filing your title dispute in federal court and doing all of that. If you don't have a game plan to block the eviction process, then all they're going to do is stall you with your lawsuit. They're going to stall you until they get to the eviction process and try to throw your ass out so that you can't fight now because you need to worry about how the hell you're going to protect your family and what you're going to do with your shit. So if you don't have a game plan to block the eviction process, you could be in trouble. And that's what I try. And that's what I tell them. Not everybody, because everybody's all worried about the sale. The sale is not the sale. You need to be worried about being the eviction. Now, with that said, if you block the eviction process, you're blocking the sale. But I don't tell people that. I just let them figure that out. Because if they don't understand that the most important thing is blocking the eviction process, they're going to screw up. They're not going to be serious about what they need to be thinking about because they're going to be worried about this other stuff, and they're not going to take it serious getting the shit in place that's going to protect you and stop the eviction. Okay, that's what you need to do, and that's what I tell people. It's more important to have a plan to stop the eviction process, and we have that plan. And I'm going to tell you the plan, just so you know, okay? Because that's how I roll here. So the eviction process is done in a lower court, which is totally illegal. And I don't know how the hell they can have it because what they're ruling on is not. So they say when you're in eviction court, they can only make a determination on immediate possession. Okay. That's how they screw you over. Because when you go into eviction court, you're going in there arguing the title dispute. You still own the title, you still own the property. They did all this illegal stuff, but the judge ain't trying to hear none of that because that judge in the eviction court can only make a determination on the title dispute. Or excuse me, the judge can only make a determination on immediate possession and not the title dispute. So if you have a title dispute filed in federal court, now you can block that whole eviction process, which we have the paperwork to do, and you can remove the eviction process from state court and connect it with your title dispute in federal court. And I have a notice of removal and everything to tell you how to do that. And all of the instructions, if you can follow the instruction, you can do this. When you remove it, you'll tell the federal court, hey, I need you to file this in my case. And you have the case number and everything on it. And they'll say, well, I didn't know what the hell you're doing. We can't, because, okay, so we don't do shit like attorneys do. So, but they have to file it. You need to tell them, look, here's the deal. This is an immediate possession issue. And the immediate possession cannot be determined until the title dispute's been settled. And the title dispute is in this federal court. And when it's settled, there won't be no need for the immediate possession issue because it's still going to be my property just like it is now. And their happy ass is going to have to go sit the hell down. So that's what you tell. That's what you tell the clerk. And if the clerk refuses to file it, then I would ask the clerk, do you have the legal authority to make a determination on my pleading? And don't say anything else. It's like selling a car. Once you put the shit on the table, now because if you say anything else, you're nervous and you don't believe what you got is going to kick their ass. Okay. So you don't say anything else and you let them respond to you. And they're not going to say anything. Most of the time, they don't say shit. They just file your stuff. Because here's the deal. At the end of the day, only the judge can deny your stuff and throw your shit out. And if they refuse to file your stuff, you need to let them know that the clerk is in violation of 18 U.S.C. 1602, obstruction of correspondence. Can't believe I can remember that off the top of my head. Yeah, I'm pretty sure that's what it is. Obstruction of correspondence. And I think it carries a $10,000 fine and a 1-year jail term. Now, when people stick that in the clerk's face, they straighten the hell up. Try it. If you think I'm kidding, try it. Like I said, I get real-time feedback from my Facebook group members from all across the United States, from California all the way to New York. And we have a program set up that we use, and that's what we do. So you need to make sure that you're addressing that. Now, let me scroll down so you guys can finish seeing this a little bit about it. Non-judicial. I just got this posted yesterday. So it's a little bit about my story and why I do this. Then we got that cute couple again. Yep, and there's my bomber plane. And you guys know I love my bomber planes. So this package is on sale also. And it comes with all of this. Plus, you're going to get some free stuff down in the bottom that we're going to talk about. Yep, here's that same free stuff. The free stuff is for everything. And there's that thing. We need to stop that. Whoops. I need to change this to $4.99 because everything's going to be $4.99. I'm giving you another $1 off. Every dollar counts, right? Okay. So, hi, Mindy. I see you there. So I'm going to leave a couple of links here so you guys can check out the new stuff, maybe. So we're going to start out with the non-judicial link first, because I think that one is probably a very important one. And we're going to leave the link right here. So there's the first link. And then we're going to do the property tax probably second, because I know that one is going to be a hot item here pretty soon, because I know a lot of you guys, a lot of people had to use their savings for property tax to make it through the pandemic. Juanita Walker. Hey, Juanita. Thanks for coming in, hanging out with us today. I hope that you find some value in what we're doing here. She's taking notes. All right. You have to check out some of my other videos, Juanita, too, because I lay it down. I don't be playing around. And last but not least, actually, this one's not last. I have one more. This one's credit card lawsuit package. So you guys can check that out. Now, I have one more that I'm going to share with you guys. This one is my special one that I'm still working on. I got to redo some things on it. So this link is to my new online course. Now I have to go back and redo some things on this, because I went kind of big on this with the fancy template, and so I'm still kind of struggling with it. Now, this online course I put together for people who have rental properties, property investors who need to protect their properties. That's what this online course is for. This online course, it has updated documents that are fire, and it has everything that you need. So you would be able to manage foreclosures for several properties at different procedures at different places along the foreclosure. So if one just started and you got one that's about to end, everything that you have is in the online course to be able to handle all of that. And the online course is at half price now for $2,400, or excuse me, it's $2,400 on half price for $1,200. But if you wanted to pay the full 24, I would. Okay, never mind. Yeah, I got a little carried away on that one. So I want you guys to check out the links that I posted and let me know what you think about my work. Okay, let me know what you think. As long as it's not things that's going to make it easier for you, because I have people tell me, "Oh, I need to do this to make it easier." How about more effective? Okay, because I'm not. My job is not to make it easy; it's to make it effective. Uh, Someday when I have staff, I can do a whole bunch of things that make things easier. But right now, I don't have staff, so we're going to stick with being effective and making attorneys go sit the hell down and leave you alone. That's the goal. Staying in your house is the number one goal. So if let me put a link to my Facebook page here too, so that you guys can join my page. Now, when you come to my Facebook page, if you want to join, you just got to answer the questions, and you got to be honest, because if you don't answer the questions, and if you're not honest when you answer the questions, then that's going to be a problem. So let me find it here. I have the Facebook group here somewhere. Here we go. Here's a link to the Facebook page. Okay, there you go, guys. So that's all I've got tonight. I hope you guys found something valuable in tonight's stream. And if you have a question, so next week I want to answer some questions that you guys have. So if you have questions, you can email them to me at when in courts one. Oops, that's not a one. When in courts one at Gmail. So if you have some questions you'd like to, now remember, these questions are not going to be about the servicer who did what. These questions are going to be about what I help you learn how to do, or about how to change what you're doing over to what we're learning how to do here, or something like that. Because I don't spend much time talking about what attorneys do or what they did or who the servicer was or all none of that, because what we do trumps all of that crap. Juanita Walker says she does a lawsuit to help stop the person from paying rent if the house is already sold. So, Juanita, I have a video, and I'll put a link to it here since I'm already here on my uh, channel that you can watch. That. So, Juanita, are you in judicial or non-judicial? Let me find that video here. So the non-judicial video is on the link to the new package, so you can go there and see it if you want. The judicial foreclosure defense instructional package, I'm going to send you here right now. Oh, that's my email. So if you guys have questions, you can send those questions to me to my email for next week, and then I'll answer them when I start streaming. So this is the video for my judicial foreclosure defense package. Okay, cool. Juanita says judicial. You should review it, Juanita. And you should also go to my website, which I will leave you a link to. Go to my website and check out the disclaimer. Scroll down to the bottom of the website and check out the questions and answers section. We answer a lot of questions that most people ask. And if you call me and you ask me a question that's already on there, then oh, that didn't work out. Will it take you to the right place? Yep. I didn't get the whole thing in there, but it takes you to the right place. So I'll just put the whole thing in there. I don't know why I didn't copy the whole thing. There's the whole thing. Oh, yeah, I see it did. Well, Juanita, you can challenge the court's jurisdiction anytime for up to 15 years. So, and my jurisdictional challenge with an affidavit is what you would need to do that. So just because they sold it don't mean nothing. You can still challenge it. You just need to have the fire that you need to get that done. And I have it. And I'm going to put a link in there to the jurisdictional challenge with an affidavit. So you can now this is not the lawsuit. This is just what you need to stop the state court process. And that's what we use this for. There you go. Oh, you're still in the house. Okay, nice. So if you're still in the house, you can mess all that up. The state court process is not as easy. It's got to follow the instructions. And you can send me a invitation to join the group, Juanita, if you're not in the group already. And then you can communicate with me in the group. I'm there like every day, but usually after lunch. I don't do a whole lot in the morning. I usually stay up late every night. So I'm really slow in the morning. So Pastor Pennington, what if you filed as a plaintiff and lost? So, Pastor Pennington, you can challenge jurisdiction at any time up to 15 years. It don't matter. And especially if you're in a judicial foreclosure, okay, the statute that they're using to foreclosure on you is not a valid law and therefore can't provide the court with jurisdiction. The statute is not a valid law because it does not contain the enacting clause, the title, or the body. The three elements that your state constitution mandates have to be present in order for something to be a valid law. So you should check out the link that I just put for the jurisdictional challenge with an affidavit. I have that on Super Coronavirus Special for only $200. And that document has been screwing up a lot of their stuff. So that's something I would suggest. That document would jam all of that stuff up and give you time to get your title dispute filed in federal court to sue them for what they're doing to you. And you can find the title dispute on my website or the link that I just put. Well, the one for the judicial foreclosure is on my website. So you'll have to go to my website to get that. So that's all I've got for tonight, guys. It's time for a glass of wine. I mean, water, a glass of water. And I will see you guys in the next video.